Welcome to Spotlight on COVID. We're here with Dr. Hannah Quirk. Hannah, would you like to introduce yourself and your research?
Hello, I'm Dr. Hannah Quirk. I'm a reader in criminal law at King's. I've been here since August 2016.
Perfect.
And my main research is I look at miscarriages of justice and the right to silence in particular. I had a book on that a couple of years ago, but I'm particularly interested in how the criminal justice system works.
Okay, thank you. So today we're going to discuss a new article that you've written, which explores the impacts that coronavirus and the pandemic has had on the judicial system. So to kick off, can you kind of tell us what impact the coronavirus lockdown measures have had on the UK's judicial system?
Yes, of course. Pretty much the same as everybody else's. Things came to a halt in March and all the trials were stopped. And they've just started to resume sort of from about the end of May in a few court centres. But because of social distancing, they're having to spread across 3 courtrooms for each trial and having the jury sitting around the court and people all in different places. So there's only a tiny number of these trials going ahead at the moment. And obviously there's a huge backlog of cases which existed before lockdown started, but it's getting worse at the moment. And obviously, prisoners who've been remanded in custody have had a very difficult time over the last few months being detained in prison.
Yeah, it must be a very difficult time to be a lawyer in the UK.
It's very difficult, and particularly because barristers and solicitors, or barristers certainly are self-employed. So if there's no trial work happening, then they've no income. So there's very real fears that they were struggling anyway due to the cuts we've had to legal aid, that many people will not be able to carry on in the profession. So there's very, very real concerns about survival of the criminal legal profession. But also they want to be getting cases to trial. Every single trial is that there's people involved. So either people who've been victims of crime are having to wait for their case to come to court. Defendants having to wait. Some of them, as I said, remanded in custody. So there's a huge pressure for everybody involved, and the government's looking at ways of tackling this, but is struggling to do so within a system that was already underfunded, and the courtrooms themselves weren't really fit for purpose in a lot of cases. So we're starting from a very bad situation anyway, and the COVID crisis, I think, has just accelerated many of the problems that we were already facing.
Now, I know the government is starting to recommence some kind of more normal trial procedures, but how is that working with the jury trial system?
This is one of the ideas that is being suggested, is that obviously you have 12 people in a jury, and for them to sit in a courtroom is very difficult if you've got to sit everybody 2 meters apart, and then finding a room that it's possible for them all to deliberate in. So a few possibilities have been suggested, having remote jury trials. There's been some projects around that. And then there's been a suggestion that keeps coming up around not having juries at all. So just having a judge trying the case. Now is the issue I was so concerned about. Juries are fundamental to the criminal justice system in this country. For 800 years, we've had a system of jury trials. Now, only a tiny number of trials get that system. Most people are dealt with either by a magistrate's court or they plead guilty. But about 2% of cases get to trial. And you can't just suddenly change the way in which trials are delivered. Lots of countries don't have juries and they have perfectly fair criminal justice systems. But our system's what's called an adversarial model. So you have the prosecution and the defense, and it's like a confrontation. And the prosecution has to prove beyond reasonable doubt that a defendant is guilty, otherwise they should be acquitted. In other systems, you have a more inquisitorial system where they try to find out the truth of what happened. Now, there are pros and cons of each system, but you can't just suddenly change one aspect of it without causing problems. And judges in this country are supposed to be like umpires. So they make sure that the legal rules are followed and they explain the law to the jury and then they sentence. But the actual decision making is done by 12 ordinary people who are just anybody off the electoral register, not off the street, who is eligible is required to go, and it's a very important civic duty. And it's one of the most egalitarian parts of the system. We've been hearing a lot in the last few weeks about bias and discrimination within the criminal justice system, and the jury is one of the most representative areas of the criminal justice process, and as such there is quite a degree of confidence in it. So if you imagine any very controversial case, if one judge has had to make that decision, how that decision is received by the public, by the defendant, by the victims in the case, is very different to how if 12 people with no vested interest in the case, who will not have a career in the criminal justice system to consider, they've come together, they've deliberated, and they've come to their verdict. I think in some ways there's a greater degree of public confidence in that and confidence amongst defendants around that.
I see it's a tricky issue. Reflecting that, so obviously there are all of these moments of kind of change and evolution in response to the pandemic. What do you think are the opportunities for change and reform moving forwards?
I think, as with most kinds of work, the courts have had to introduce internet, and remote conferencing. So lots of hearings. There's a lot of inefficiency in the criminal justice system. So everybody having to go to court to set a date for another hearing in 3 months' time. That doesn't need to be done in person. A lot of that could be done much more efficiently and effectively by remote links. And I think a lot of practitioners have said this is a real bonus. We can look at other means, but I think we need to consider two different things: how efficient the system is and how fair it is. And obviously efficiency is much easier to measure. So you could look at how many hours of time have been spent in court, how much things cost. That's quite an easy tick box thing to do. But in terms of people's trust in the system and their confidence in the system, that's much more difficult. And if you imagine if you were on trial for an offence, if you were entering a plea at the police station by video link, you don't get a chance to see your solicitor in person, for example, or you don't really feel you've had a chance to present your case in the way that you'd want to. So if we're having a conversation like we're having, we've got a stable Wi-Fi link, we've got laptops, we're both used to talking in our first language. If you are a defendant or a witness, for example, who only has a tiny little phone, perhaps maybe not even their own phone, they've had to borrow one, their English isn't great, they feel quite overwhelmed and frightened by what's happening to them, how they feel at the end of that process is going to be very different. And also the effectiveness of things like the judge's sentencing remarks to them, if they're explaining why they've given the sentence that they have done, what they think that the defendant has done wrong. There's quite an important theatrical almost aspect to being in court, that it's supposed to be a grand building and judges are sentencing on behalf of us all, really. Much of that can be lost if it will be done on a phone link or almost like a conference call. So I think it's important not to throw everything away. We need to deal with this backlog of cases, but there was a huge backlog of cases before the COVID crisis. We had something like 37,000 cases waiting to be heard at the Crown Court. That's gone up to over 40,000, which is appalling. People are having to wait 18 months, 2 years for a trial date, and that is wrong. But it's important not to throw away things that are a very precious part of our system too, just for very short-term convenience, because once the jury trial has gone, I suspect it will be very difficult to reintroduce it. And I think there will be something very precious lost from the system if we do that.
Yeah, it's so interesting. Thank you so much, Dr. Quirk, for joining us today.